whether the question as to whether the fact that the third report of Mr. Quayle was available to the claimant before the CMC was or was not a matter that was argued, I think, specifically before the circuit judge on the first tier appeal. To which the answer is it was. It's in the appellant's learned friend skeleton argument for that appeal. I'll give you the reference. It's in the core bundle at page 109, paragraph 11 and 12. It was a matter that was clearly part of the argument that was addressed to the learned circuit judge on the first tier appeal.
Thank you.
I think that brings me to Elliott and Stobart, which was the case that learned friend referred to earlier. This is the case management. Again, for the note, it's at page 63 in the authorities bundle. And this is the case where there was a case management order requiring service of a psychiatrist's report by X date to support a claim that a prohibitory injunction had psychiatric harm and other consequence for the defendant. The order that was made in that case, that was set out in the judgment on appeal, is at paragraph 23. We turned it up earlier. It's an order that was made by His Honour Judge Appellant at a case management conference, to which a consequence was attached. The consequence being that if the psychiatrist's report was not served by X date, and there was no application by the defendant to vary or discharge the order that had been made, then the claimant would have, as it were, liberty to apply to strike out those parts of the defendant's claim that related to the alleged psychiatric injury. That then came back before the court on the extension of time application, a cross application to strike out those parts of the claim that related to the psychiatric, the alleged psychiatric injury. This was treated, when I took you earlier to the relevant passage in the judgment. This was treated as an implied sanction case. This is paragraph 43. At least as a case where relief from sanction was required on the part of the defendant if he was to be relieved of the consequences of the breach by a grant of an extension of time. The slightly puzzling aspect of this case is that I confess I don't fully understand why this was not treated as an express sanction case. I'm not just parroting what was said from the bench earlier, but that was my note of it on reading it and then rereading it in preparation for today. There was a consequence that was attached to this order, and that consequence was triggered, and therefore it's not altogether surprising that this was treated as a relief from sanctions regime case. It fits more naturally into express sanction, albeit it's not a striking out as such, quite a further step. It's a very weak sanction, but a consequence nonetheless. It might also be characterised actually as a 35.13 case. And there was an order for disclosure of a report from an expert in an identified field, being psychiatry. It might have been looked at again in express sanction terms on that basis. The reason for treating it as implied is not really discussed in the judgment, but there it is. I think it can be characterised as that. S.J. Moore Limited against Squid.
There isn't, sorry, there isn't a copy of Judge Platt's in the. I'm sure there isn't, but obviously this is just a transcript. I don't know if this case is reported. I think it is, isn't it? And I wondered whether Judge Platt's decision, because what the paragraph that refers to implied sanction actually says is it says that the judge below was right to refer to it as implied.
Yes,
sanction.
quite so. Yes.
You're not aware of that.
I can make some.
No, that's fine.
I'm afraid I'm not aware. I was going to move on to S.J. Moore Limited against this is the case where there was an application by the defendant for permission to rely on witness statements served late and expert evidence in two new categories. So this was an expert evidence case. And the application was filed and served, I think, within about 4 weeks of the trial date, impairing the trial date, which I say is a clear point of distinction with the present case. We do say that that provides an obvious explanation for the outcome in that case, which is the peril of the trial date from the mass of new material and expert evidence included within that coming in. But we do say that the approach in principle and the starting point, which is to treat this as a relief from sanctions case to which the full rigour of dental, etc. should be applied, is, with respect, the wrong approach in principle. And to that extent, we adopt the way that this case has been discussed in subsequent decisions, most notably in the T&E Imperial case. That does bring me, lady, to Mark and Universal Coatings for a relatively short, I hope, delay, which is the Mr. Justice Martin Spencer decision, to which I refer to the break. This is at page 186 in the authorities bundle. And this case is of some significance. It's an appeal case, so it's a decision on appeal to the High Court judge. The context is claimant serving particulars of claim, but without compliance with Part 16 practice direction requiring in a person injury context a medical report and a schedule of loss, so they weren't included within the service of the P's of C. And the defendant applied to strike out the claim. And the question, in fact, the point at first instance was that this was dealt with and approached as a relief from sanctions scenario case. But on appeal to Mr. Justice Martin Spencer, this was treated as not a relief from sanction case, but even on an implied sanction basis. And the interest in this decision, I submit, is that it does seek to provide some explanation for where and how the implied sanction cases can be explained and understood. And that finds its way into the judgment. There's a discussion, actually, perhaps I should pick it up here, of paragraph 46 in the judgment, if I give you that on internal page references. Mr. Lim was the counsel for the defendant.
And it's there. It's the fact that that's where you get fundamental from.
Well, I'll develop it. It comes back, actually. I mean, the word fundamental is mine. Apologies, rather than...
This is still submission.
It is, exactly. It's an argument. This is not judgment. But the point that's being confronted here is this, which is, I mean, if these cases were just all about express sanction, they'd be easy. The problem is that it's gone further than that in the appeal setting at the time that this was decided to implied sanction for Sayers and Clark Walker being the notice of appeal going in on time, and then the Salford Estates and Altamart, which is the respondent's notice. So it's already gone further than express sanction, and therefore the line is not as bright or clear as perhaps one might hope if one's looking to signal clearly to parties what is expected of them. And so what the court is grappling here with here, and what counsel was trying to assist the court with, perhaps not to the complete satisfaction of the court, was how you go about explaining those exactly implied sanction cases in a way that would make sense of them and provide a guide to other settings where this point might the attempt that was made by counsel was, well, if it's really important, or a particularly egregious failure, then that might carry an implied sanction, provide some form of explanation. But Mr. Justice Martin Spencer's approach to this is picked up at paragraph 51 through to paragraph 52, and it's paragraph 52 where he provides an explanation for the implied sanction cases.
What's the logic of that? If you fail to serve an expert's report, without which your case is doomed to fail, that's highly significant for the purpose of the case, and therefore you need to apply for relief from sanctions. But if you fail to serve an expert's report, which means your case is still viable, but the expert would have given you a bit more damages, that's not really all that significant, and so you don't need to apply for relief from sanctions. Where's the principle there?
Well, the principle that it was obviously being looked at specifically in the context of an appeal setting, and these matters always arise contextually in the context of a particular application, and it is.
Well, all right. A respondent's notice, which on the one hand would completely change the scope of the case, and on the other would just have the effect of giving you a bit more damages.
Well, I mean, actually, Mr. Justice Martin Spencer says that respondent's notices are rather close to the line, as he observes himself, although he accepts, bound as he is by the Court of Appeal Authority in the Salford Estates case, that makes sufficient difference to the merits, as it was explained, the merits of the appeal, the respondent's position on the appeal, as it was explained.
Well, all right, maybe not good examples, but the principle which he sets out, what's the logic underlying it?
Well, actually, the logic is that if it makes such a, and the answer is provided in I can't do better than what appears alongside D, which is that this is so significant for the purposes of the litigation that the need to apply for relief from sanction is implied, and that's an explanation for what happened in the appeal setting in those cases. What you see, by submission, respectfully, in the Mark and Universal Coatings case, is a very marked reluctance to go any further than it has gone already. In other words, this is a sort of incremental development of the law and an attempt, perhaps not a wholly satisfying attempt, to provide an explanation for it on a principled basis, but a marked reluctance to go any further because of the consequence. This was going to be my final point on this authority at paragraph 54, because the consequence would be that the courts would be inundated, as Mr. Justice Martin Spencer puts it, with a multiplicity of relief from sanction applications.
Well, it sounds to me as if it's introducing a new element significant for the purposes of the litigation, which is pregnant with applications about whether something is sufficiently significant.
Yeah, I mean, I take a step back from that. Actually, what he's doing is attempting to explain the implied sanctions on cases on their own terms, with a degree of doubt, in fact, about whether this test, if a test it is, would be met in a respondent's notice context, and a very marked reluctance to go any further than that. And it's the reluctance that I particularly draw to the court's attention, rather than the attempt to explain retrospectively the principle that was at work in the appeal setting cases. Tea and Imperial College. This is a good example, and in my submission, something of an answer, together with the Chaplin and Pistol case, to the charge that if you leave these sorts of case management applications to the general discretion of the case managing judge, that you automatically end up with a more lenient result or approach. and my submission is not so. T and Imperial was the defendant's application. I should give you the page reference within the bundle for that.
23.
Exactly. It was the defendant's application for permission for the parties to rely on a single joint expert report from a geneticist, an application that was made after the completion of directions but before the joint statement of the experts, where the trial date was set and was likely to be imperilled by the application being successful, especially if, as the judge preferred on submissions that were made, both parties were granted permission for a geneticist rather than a single joint expert. And Mr. Justice Stewart referred in some detail, paragraph 22 of the judgment, to mark and universal coatings, and concluded in paragraph 22 also that S.J. Moore and Squibb was wrongly decided. And the material portions of the judgment in T and Imperial, Millennium will also recall that this was the case, the first instance case that was referred to in the grant of permission to appeal by Lord Justice Lewison. At paragraphs 21 through to 25, you'll see first S.J. Moore referred to, then mark and universal coatings at paragraph 22 with a lengthy passage of the judgment set out, then reference to 35.4, just pausing there for a moment, Malone Friend places a lot of reliance on, as I understand it from his submission, on 35.41, and as I understand his submission is that it contains a sort of implied sanction within it. That was not the conclusion that was reached by Mr. Justice Stewart in that case, and I understand that Malone Friend's position is that that was wrong. And then there is reference at paragraph 24 to the principles to be, or matters to be taken into account on the basis of very late applications, which are explained by reference to another authority as those cases where the trial date is imperiled. And the outcome of this is that the relief from sanctions regime is not applied. At paragraph 34 in the judgment, the factors in play on the exercise of a general discretion by reference to the overriding objective of recount, and the application is refused.
Does Mr. Justice Stewart identify the breach that he's dealing with anywhere? Mr. McLaughlin submitted that he didn't.
Well, he didn't. He certainly had regard to case management failings in the general sense, because he refers to them in terms in paragraph 34. The identification of the breach.
Well, I think you would accept that there are case management failings in the general sense.
Yes.
In this case,
Oh,
our case.
Yes.
But what's the breach that Mr. Justice Stewart is dealing with?
Give me a moment.
I suppose Mr. Stewart didn't have to find a breach because he doesn't think it's released from sanction.
Well, I mean, that would be my short answer, which is that breach becomes less, a specific breach becomes much less important if you're not looking at in a 3.8 and 3.9 sense to the sanction that flows from the breach. If it's case management failings, and that is a reason why you should not have the permission that you seek, or the extension of time, then identifying with any degree of precision the breach, and even more importantly, the sanction that flows from it, whether express or implied, becomes a less important part of the overall case management exercise. Chaplin and Pistol, page 119 in the authority bundle. This was a different category of expert evidence, but expert evidence again, the defendant's application for expert evidence as life expectancy. The defendant seeking a variation of a CMC order that had been made by the master on a change of circumstances basis. This is a decision by Mr. Justice J in 2020. There's reference at paragraphs 38 to 39 to the T and Imperial College case we just looked at. And again, an approach to case management, the decision that needed to be made on the application for expert evidence that was subjected to the general discretion rather than to relief from sanctions. So again, with a refusal, in fact, of the application of relying on Professor Strauss, who was the life expectancy expert that the defendant sought permission for. So again, an example of fairly robust case management, not by reference to relief from sanction, but by reference to the general discretion of the overriding objective.
Doesn't Mr. Justice J in this case, he says something about Rule 29, doesn't he?
Give me a moment.
Maybe I'm misremembering. I apologise if I'm setting a hair. Do take time.
Well, it's a paragraph 24 where that's set out, the practice direction to part 29.
Oh yes, that's it.
And some of the, which are the provisions in the practice direction on changing circumstances. But that's certainly not regarded as it were, requiring the relief from sanctions regime and all its machinery to be applied, as opposed to a general discretion that was ultimately exercised against the defendant on its application for expert evidence.
I suppose we could all agree with the first sentence of paragraph 24.
Yes, indeed. I mean, and that's the basis on which Lord Justice Lewison granted permission. The question is the starting point, the trigger, as it's been referred to in some of the cases. Whether you go straight, you leap for relief from sanction, or whether you leave it to the general discretion of the overriding objective. FXF, which is the recent decision of this court in relation to a judgment in default. There's again a detailed tour of the authorities in this judgment, but actually not of, I can understand why, because most of the authorities, or at least a number of them, are dealing with applications for setting aside judgment in default rather than other case management settings. But the Mark and Universal Coatings case is one of those which is not in the list that appears in the judgment. There is a three, as my learned friend has taken Lady and Lords to already, in paragraph 59 there are three categories of case which are identified. The first category being express sanction, the second category being implied sanction, but not necessarily the same characterisation of implied sanction that's been referred to in some of the other cases. Category 2, which are cases where the rule does not expressly state the sanction which applies for non-compliance, but permission of the court is needed to proceed. For example, a failure to file a notice of appeal on behalf, which is the way in which looks at an implied sanction was looked at in that context. There wasn't any further discussion of those category 2 cases, implied sanction in this, because this was treated as the third category, within the third category of relief from sanction case, which is those, as explained in paragraph 59, the cases where a further step is taken in consequence of the non-compliance, such as the entry of a judgment in default. The case proceeded on the basis that this is a category 3 and subject to relief from sanction rather than either of the other two categories. Lufthansa, which is bringing us right up to date, in the, at least to me, exotic setting of an island records order, about which I know far more now than I did
Well, we're glad to have added to your education.
It's been most educative. This follows, in my submission, this judgment, an approach which I pray innate for obvious reasons, attaching myself to it shamelessly. CPR 30, the starting point is that you look at CPR 3.8 and 3.9. They only apply where there is a So it's important not to look. It's more important to look at the sanction than it is the breach, because it's only if there's a sanction that you state the obvious that you need relief from it. Sanctions at paragraph 21 in the judgment of the law may be express or implied. Referring to mark and universal coatings at paragraph 22 of the judgment, not every case management decision for an extension of time has a sanction applied to it, whether express or implied. And the clue to this, it's said in paragraph 22, is to look at what the default position would be if the extension of time or other relief is granted. And there is a difference of, in answer to the point that's sometimes raised, and you see a ghost of this in some of the authorities, which is it really doesn't make very much difference whether it's relief from sanction or whether it's general discretion. But I do adopt, respectfully, what is said about that argument in paragraph 23, which is there is a difference of substance, which is that if there's a sanction in place, you obviously need relief from it. You start, as it were, 1-0 down, you've got to come back. Whereas if you're seeking permission, the court necessarily has a freer hand. I mean, I'd add that relief from sanction applications are supported by evidence. That's in in a variety of, it's in 3.93, I think, from memory. They will be supported by evidence. A lot of case management applications made after the first CMC are not necessarily supported by evidence. They might be made in the face of the court. It would be cumbersome and result in a great deal of additional time and expense, court time and party time, to require all of these applications for extensions of time in a variety of different settings to be accompanied by evidence and to require the full machinery of a relief from sanction application. There was an argument, an attempt at an argument, it seems in this case, that in some way CPR 31.21, this is in paragraph 30, being the provision in the CPR that deals with the consequence of failure to disclose a document or permitted inspection might in some way on policy grounds be extended, whether by way of express sanction or implied sanction, to import a sanction into this context to the requirement for disclosure on item record order application. And that attempt to extend that rule, bring it within the remit of the relief from sanctions regime, was resisted by the court. It should so be resisted in my submission in this case. Lady and Lords, I'm going to, as it were, I hope, fairly briefly summarise my submissions, so far as they're not dealt with in the skeleton argument. The first point I make is one that I've already raised while we've been looking at the authorities, which is that following the line that was adopted by Lord Justice Moore-Bick in the Salford Estates case, CPR 3.91 should be read in the context of CPR 3.81, which refers to a failure to comply imposed by the rule, practice, direction or court order and requires there to be a sanction from which relief is needed. So it's not just a breach, it's a sanction, and the sanction is probably the more important part of that. As I said earlier, if the rule, practice, direction or order contains an express sanction, then it's easy. And examples of that are failure to serve a witness statement in time, CPR 32.10, failure to disclose the report of an identified expert, CPR 35.13. The difficulty, of course, is that most, and indeed as Lord Justice Moore-Bick observed in the Salford Estates case, most rules, practice, directions or orders do not identify the consequences which should follow from a failure to comply. And there have been, albeit incrementally, some extensions of the sanctions regime to the appeal setting and very recently to applications to set aside judgment in default. And there was an attempt at an explanation, as discussed by Mr. Justice Martin Spencer, which is difficult to attempted a sort of retrospective explanation of the appeal setting cases, but a marked reluctance to go any further than that. There are a number of cases which authorities we've seen in the bundle of first instance where there were very late applications imperiling the trial date and may provide an explanation of the outcome in those cases, even if I part company with Cameron saying the QC issue then was in the SJ Moore case with the approach that was taken in principle. But I do say that the category of cases, case management decisions, that don't fall into express sanction and don't fall within implied sanction, don't fall to be dealt with under 3.91 and Denton, but do require the exercise of the more general case management discretion. If the default position in this case is that if the application had succeeded, this case would have proceeded to trial with pain management expert evidence, quite possibly, probably on both sides of the court. The court may or may not. This is a case where liability is contested as well. So if we'd got as far as quantum, the court may or may not have accepted the pain management expert evidence on the issues that it was likely to deal with, causation, conditional prognosis. If conversely the application had not succeeded, the case would still have proceeded to trial on liability and causation and quantum, the court would have had the benefit of Mr. Quayle and Mr. Oxborough both saying that we think there's some pain element in its most general sense in this man's presentation, but without the benefit of expert evidence on that point. That, my suspicion, is not an optimal approach. So, this is not a case where the application had any impact on trial date or trial window, and it is, in my submission, too mechanistic to adopt the approach that's urged by Learned Friend, which is to effectively seek to apply the relief from sanctions regime to everything that happens by way of an extension of time after the first CMC. That would have consequence, which, in my submission, would be unfortunate. Require evidence, applications, and a great deal more court time on these issues, which is largely what happened actually before Denton explained what the court had in mind in Mitchell. It was a refinement, but more of an explanation of what the court had in mind. Mitchell having prompted a very large number of applications and a great deal of court time and energy. And that was clearly something that Mr. Justice Martin Spencer was concerned about, as he said, in marking universal cases. My final point is that if the underlying concern is that permitting a procedural judge to use a more generally expressed discretion is necessarily going to result in a more lenient approach. I do say it's not necessarily so. All that one is enabling the court to do is to have regard to all the circumstances and not necessarily requiring an application supported by evidence. The examples of that are Tierney, Imperial, and Chaplin in Pistol. Can I very briefly turn my back? Those are my submissions.
Thank you.
Well, Mr. McLaughlin identified what he said were about half a dozen breaches. Have you got any submission about that at
Yes,
all?
I mean, I acknowledge that that it is a requirement under the rules to make application at CNC for permission to rely on expert evidence, because that is a requirement of 35.41. And it was acknowledged that that had not been done, and that therefore that was an application that was coming to the court late. So far as Part 29 is concerned, and in particular the variation directions, maybe a rather semantic one, but the claimant was not to take the introductory words of Practice Direction 29, paragraph 6.1, 1, the claimant was not dissatisfied with the directions that were given at the CMC. The claimant wanted to supplement them with an additional expert, which required an application that the court would supervise and police, as 35.4 makes clear. That's not a sanction. These are not the important, as I submitted earlier, the important thing is the sanction, not the breach. It's questionable, in fact, whether there was any breach of the practice direction of Part 29. The failure to make an application at the CMC in respect of the steer or recommendation that had been made by Mr. Quayle might arguably be regarded as a breach. But it was an application, as I say, was subjected to 35.4 and required an application to the court. That was done. It wasn't us applying for relief from a sanction that the rules, practice direction, or the order imposed.
And so you would characterise it as a late application, then that's all.
Simply a late application.
Mr. Chairman, if the judge at the case management conference had made an order which says the expert evidence in this case will be served by date, and then said you have permission to rely on an orthopaedic surgeon, why would you not be in the same position as a party trying to file a late witness statement and faced with Charlton?
Well, I mean, the argument then would be that, the question is whether 35.13 applies, which is disclosing a report.
Yes.
In that regard, as I think you say in the skeleton argument, we adopt the approach that's suggested by the learned editors of the White Book. They suggest that the assumptions made in 35.13, as is the position in 32.10 dealing with witness statements, is that an order has been made for service, and once it's been missed.
Well, that was the premise I put to you.
Yeah.
An order is made for expert evidence, and the date is set for expert evidence. And indeed, I think actually the order in this case says exactly that. It says simultaneous exchange of, but that's witness evidence. I'm sorry.
Yeah.
But it does refer to, it sets dates. Obviously, the only reason you're not in breach of those orders is because they were specific to orthopaedic surgery.
Yes, that's right. That's absolutely right.
But it feels a bit like happenstance that the order made at the CMC wasn't drafted in a slightly different way.
Well, I think
which would have said the expert evidence in this case shall be served by.
Yeah, I follow that.
I'm bothered that
yes.
a great deal of difference seems to hang on that rather, happenstance way of drafting the
But
direction.
35.13 is dealing with a slightly different situation, which is that I got permission for an expert, I've obtained it from the court, I'm sitting on that expert report, and I'm not prepared to disclose it, and then I change my mind. That's rather different. That's different in my submission in character and form, and it's certainly treated differently in the CPR rules from the situation here, which is for whatever reason, and the whatever reason will be dealt with on the exercise of the judge's discretion and still be looked at from the situation here, which is for whatever reason, I'm making an application, fresh application for fresh expert evidence.
Well, I understand.
Which is different.
But on the basis of that analysis, the defendants in these PI cases are going to ask judges at CMCs to make the order I've just described.
Well, they may well do.
Why would a judge not do that? I mean, it just seems to me to be the same order but drafted in a different way.
Well, I don't think it is the same.
Because what then happens
Yeah.
is the claimant then says, I'm thinking possibly about pain management, to which a white book nerd would say, well, you should have been telling us about that, because that's what, if PD 29 means anything, it means you're supposed to at least talk about that stuff at the CMC.
Yeah.
And you would have ended up in a Boyle, I think it's Boyle, no it's not, which one of the cases we've got anyway, where the judge says, right, well I'm going to set a date when you've got to come off the fence.
Yes.
On
That's the I think you're thinking rule of MS Croydon, which is there are various disciplines that must play, and you've got to apply if you're going to apply.
Which seems very sensible to me.
Yeah. But there are all sorts of reasons why parties may or may not, at the time of the first CMC, have in mind or wish later, wish after the first CMC to apply for expert evidence. mean, there is a reason in this case, which is there was a subsequent file reviewed by a different figure.
But it seems, I must say, I'm very struck by the stark difference between the position of expert evidence and fact evidence, because if there's a date for fact evidence, as in every case, when that date's gone past, if a party pops up and says, "Oh, I've thought of a new witness I'd like to call," that's relief from sanction.
Yeah. Well, I agree with you. That's 32.10.
It's nothing to do with the subject matter or anything.
Yeah, and the same would be true if there is a named expert. If the expert is named, as in the Croydon case, the MS case, because then you've got CPR 35.13, express sanction again. I mean, actually, what happens then is if the party is unable to meet the date, they can make a prospective application within time.
Right. Well, that's a different thing.
Then there would not be a that's Robertson Momentum.
That's a different thing.
If they make a subsequent application, having allowed that date to go past, then of course it is relief from sanction under 35.13. But the reason I suggest to Lady McGraw's why there is a difference between that scenario with an expert and the scenario that we're looking at here is that the mischief to which 35.13 is concerned is there is an identified need for an expert in that field, and for whatever reason the party has said has decided not to serve it within time and then changes their mind. And that's the way the court releases that. But other than that, I mean, the court would be extending this regime into a factual setting, case management setting, to which this has not yet been applied.
Just one other question, if I may. Suppose this is a relief from sanctions case, i.e. we accept Mr. McLaughlin's submissions. What then?
Well, the court would embark upon the 3 steps, 3 stages in Denton, and would have to consider as part of that exercise the 3rd stage, which is whether in all the circumstances of the case the relief should be granted. And it's our submission, and this is the reason, something of an excessive caution, the respondent's notice was put in. One of the ironies of this, of course, is that was put in late, which is embarrassing. I may as well front it out. Yes, we will. But we do say that in the skeleton argument, this is a very secondary argument, that if the starting point is Denton, then we would submit the reasons that are set out and rehearsed both at first instance and first tier appeal. When I say that, I hope not undermining the principal submission I made, which is the starting point is general discretion, not relief from sanction.
Thank you very much indeed.
Thank you, Millie. Very briefly, I didn't refer to Chaplin and Hicks in my address for good reason, and that is because if you look at it closely, it has got nothing to do with your considerations on this appeal, and I'll just demonstrate why. Can my lady and my lords look, please, at page 123 of the authorities bundle.
Page 123, this is Chaplin of Bristol.
Yes, page 123 of the authorities bundle. It's paragraph 14 of the judgment of Mr. Justice J. It is crucial to note that the defendant was not in breach of the Practice Direction Part 29. The defendant made an application at the CMC for permission to rely on the joint report of Professor Strauss and Dr. Brooks. That was on the issue of life expectancy. If you then look at paragraph 19, you will see it says in terms that the claimant solicitor made a note of Master Eastman's reasons for refusing the application. So it was raised and it was dealt with. So there was no breach. If you then look down to paragraph 23, my lady and my lords, you will see, reading from 4 lines down, counsel for the defendant, Mr. Brown, submitted there had been a significant change of circumstances. Mr. Weir, the claimant, took a different view. the defendant didn't appeal, and whether that was right or not, there'd been no relevant or sufficient change. That was the issue on this application. If you then look at paragraph 24, the judge then outlines paragraph 24 because, of course, outlines the practice direction 29 because this deals with what you're supposed to do if you want to vary an order, and in particular, he rehearses 6.2, 6.3, and 6.4. And then at paragraph 25, the judge says this: in the light of these provisions, which reflect no more than the basic principle, a party aggrieved by a court order must either appeal it or demonstrate a change in circumstances. Mr. Weir submitted it's incumbent on the defendant to show a relevant and sufficient change in circumstances. I accept that formulation. So, practice direction 29 was not being discussed in the context of relief from sanction. It was being discussed in the context of an assertion by the defendant that there had been a change of circumstance since the master had made the order. And if then one looks further on at paragraphs 38 and 39, yes, Mr. Justice J asks himself, well, even if he's wrong in his conclusion that there was no material change, in other words, he's proceeding on the basis that there was, he then asks himself, well, should it be excluded in any event for coming too late? And he follows T and Imperial. And I've got no problem with that, because, of course, the defendant was not in breach. He's not making a decision on whether the relief from sanctions analysis is applicable, really, because it was not asserted that the defendant had been in breach. No breach was identified. As I explained in my address, it is crucial when determining whether 3.9 applies, whether the relief from sanction analysis applies, not to jump to sanction, to ask first, was there a breach? Second, was there a sanction, however imposed? And third, was there a need for a retrospective application? The question of whether there was a breach did not arise in this case. It's not addressed. It is of no relevance to this appeal, this case. And the fact that Mr. Justice J followed T and Imperial College means nothing. It provides the respondent with no support for the position it's adopted. That's the only point I wanted to come back on the law. Otherwise, I shan't repeat what I said in my address.
Most grateful. Thank you. Thank you very much, in fact, to both of you and all those behind you for the amount of work that you've put into this case and for your very helpful submissions. We will reserve our judgments on this important issue, and you'll all be aware of the way in which these things are dealt with. Our judgments or judgment will be circulated for correction of typographical errors only, and no further argument at that stage. You'll also be aware that we're particularly concerned about the embargo which applies to that draft or drafts when they go out, and I remind you again about that. And then, in the usual way, the judgment will be handed down electronically, no need to attend, and we hope that you will be able to agree an order. If you're unable to agree an order, then a very short submissions, please, in writing, and we will decide what is the appropriate course to take. Thank you very much indeed.